So were there any questions with it?
So in the absence of a deadlock arrangement
Yes.
that's been articulated, is the fallback of the law to take it to the court?
That's right. And ask it to wind up the business on the basis that it has become dysfunctional and can't run itself. So for instance, the sorts of things that happen are we've got a bank account with cheques that have to be co-signed and no one's going to pay cheque. So now the business will simply not pay cheques, will be in default, will have to wind up anyway. They can't make any decision about anything because they're deadlocked.
But on what basis does the court make the decision as to how to resolve the deadlock?
On the basis it's the right thing to do. It's just you.
But they still have to make the same decision.
No, they don't resolve the deadlock. What they do is wind up the company. They just shoot it. They just put it to bed. The court doesn't run the business. The court's decision is this business is now defunct. The best thing for the parties is simply to wind it up and sell off the assets.
What process do they go through to determine the dysfunctionality of the...
So a hearing, evidence, argument. Is it worth keeping this thing alive? Is it so dysfunctional that it should be put down, or is this, should they work through their differences? Doesn't matter. In most cases, it'll be put down because a deadlock will generally mean that the business isn't going to pay its debts, and if you're not paying your debts as and when they fall due, you're insolvent, and if you're insolvent, your director's duty is not to trade.
Would there ever be a circumstance where they would appoint a mediator for the good of the business? I mean, if there's one like, okay, sorry, my name's Joy. Everybody, sorry for being late. I do apologise. I've had a partnership just collapse and threaten the company, and it's all amiable now, but it really did come very close to threatening the life of the company. But it wasn't a company that I wanted to give up. I just didn't want to be the only partner contributing to the business. So I would have, if it had come to that for me, I would have rather had a mediator appointed and work something out between the two of us, because we were never going to do it on our own. Eventually we did, but it was looking for a while like it wasn't going to happen. So, or by the time you get to that point where you take me to those courts and they're just going to say, look, if you're here, then there's nothing else can be done, we're going to push through and close it.
So the court might appoint a mediator to try and help resolve the dispute, right? But the mediation is only by agreement. The outcome is only an agreed outcome, and the mediator won't have any power to simply override what the parties want and make something happen for the company. The only way to do that is to put it in the hands of a receiver and manager. Very difficult. And your situation has highlighted another potential problem in all of this, which is when you go into business with people. So very often this is what happens. You go into business, you say, how do we do it really cheaply? We go to ASIC and we register a company and it costs us $620. Great, we're in business. Yeah, except you've now bought a company where you own half of it, they own half of it, and they've got no obligation to contribute to it. They've got nothing except ownership of the company, nothing except their rights and obligations as shareholders and directors. And what you really needed was what's called a shareholders agreement, which is effectively a partnership agreement for companies that outlines who will do what, sets out some basic parameters of what people will do, but most importantly, it gives you the right to kick people out and to buy their shares back in certain situations, so that you can simply resolve a dispute by buying someone out. Now, without that agreement, you're wedded at the hip. And without that agreement, in this situation, Angela could go to the south of France and she's still entitled to half of everything. Now, it's a marriage, so it's a slightly different situation, but that's a key issue in any business partnership, is that there's some agreement that locks down basically that people will devote their time, skill and attention in good faith to the development of the business. And if they don't, that you have the right to forcibly acquire their shares. Now, in this situation, they have this weird clause where there's 500 shares, but we can buy them back for nothing if you leave the company. That's a little bit unspecific about what all that means. But it's not really relevant here because the shares are owned, we're talking about the shares in the trustee. And the trustee, while they're the legal owner of the business, they're not the real, that's not where the real game is played in terms of ownership. The ownership is discretionary trust. And so losing all my shares in the trustee is neither here nor there, except for control. So shareholders agreement, particularly if you're going into arm's length arrangement.
Why family trust?
Hey?
Are there other models other than the family trust? Or?
So what a family trust is, family trust is something you use to hold your assets, right? So if you've got a business, you have the shares in that business and you will tend to have those shares in your family trust. Why? Because the dividends coming out of the business payable on those shares is non-personal services income, so it's alienable income that you can distribute to whoever you want. And so if it's held in the trust, you can now distribute that shares, that dividend to any of the beneficiaries of the trust. And it helps minimise your tax. You make use of everybody's minimum tax thresholds. You know, I don't pay it to you because you're at the maximum tax threshold because you've got a high paid job, so, you know, and it's a way of keeping tax down. So a family trust it should be a holding entity. It shouldn't be a trading entity. Okay. Self-managed super fund. Who's heard the phrase in-house asset? So, people regularly, so you're paying lots of money to the trustee of your super fund and you're sick of it, and so you go and you set up your own self-managed super fund, and now all these wonderful hundreds of thousands of dollars are sitting in a bank account that you actually have access to. Wonderful, now I can buy stuff. So what I'm going to do is I'm going to buy my family business off myself. No, you can't do that. I'm going to buy my family home and discharge my... No, you can't do that. I'm going to buy a home and I'm going to rent it to myself. No, you can't do that. Right? An in-house asset is basically any asset that is providing a benefit to a member of the fund or any person or entity related to a member of the fund. Now, related is this broad, right? It's not just your spouse and all your kids and all your grandpeople. It's all the businesses that those people control or have a majority stake in, etc. Right? It's really, really broad. It's an attempt by the tax office to crack down on this business of people using their super fund for their personal benefit. Now, the stupidity of it is that I can use my super fund to pay off your mortgage and charge you to live in your house, and you could use your super fund to pay off my, you know, we could do it if it's not in-house, but anytime you see somebody who's using their super fund to buy an asset and they get a benefit out of it, a red flag goes up. That potentially this is an in-house asset, potentially you can't do it. Potentially there's problems. In this particular situation we've got two. There's the family holiday home, which we say is leased out over the period, but we tend to lease it back, you know, for school holiday, you know, so it's not real lease out, it's just so that we get a tax deduction for the interest cost on the loan, etc. And the horrendous rates that the Uruvidella Shire Council charges for land tax. Potentially that family home shouldn't be in that, can't be in that super fund. We've also guaranteed loans through the super fund, so we've been doing some stuff, we haven't had the equity or the collateral to be able to do it, and so the super fund has stepped into the breach and lent its shoulder to the wheel. Again, that'll be potentially in-house assets. Super funds can't lend, and so there are potential fines and penalties and loss of the self-managed super fund status. Potentially this is a non-compliant super fund, which would be a nightmare because when you contribute to your super fund, you claim a tax deduction for the super contribution. If you contribute to a non-compliant super fund, those contributions are no longer tax deductible. So now I've contributed to my super fund out of after-tax dollars, not pre-tax dollars. Yeah, and the problems roll on. I've seen an example of this problem with in-house assets. I mean, this is, you're into tens of thousands of dollars to solve those problems. Reconstituting the accounts for your trust and trying to solve it, negotiating, etc. The other issue with the self-managed super fund is the beneficiaries are trustees. You need to think about this if you're in a self-managed super fund, and there was a really recent case. So all of the beneficiaries of a self-managed super fund are also trustees. If one person dies, then the other person remains the trustee, and so they control the super fund of the person who's just died. And in a recent case, the person just went nuts with the trust money because they controlled it. And now they didn't have to do anything with the money that the person had wanted to have happen in their will. because there was no binding death nomination. The documents weren't in place to force the trustee to obey the wishes. And so now what I've got is I've got your super money, you're dead, and although you might have said you wanted to go to the kids, well, I'm not going to do that, all right? I'm the trustee, I get to decide where it goes, and I'm going to decide it goes to me, as your spouse. So, self-managed super funds, fraud, need to think about them. Ideally, we're removing the in-house assets as soon as possible, and there may well be some sort of mea culpa to the tax office in respect to those. And I haven't expressed a concluded view about this. This is red warning flag, right? These are, again, thousands of dollars worth of time and advice to find the answer to those questions and to advise you on them and tell you what to do about them, right? This is the cost of doing it wrong, the cost of not doing it with proper advice. It's the extra cost of fixing it up after the fact. Any questions? Right, so by and large, your self-managed super fund is not a pot of gold that can lend its shoulder to the wheel to solve your problems. There are exceptions to that, and lots of people make lots of money telling people how to get around the rules of the super fund. But by and large, your super fund's not there to help you in your day.